A manifesto issued by a political party in order to get votes is not to be taken as gospel. It is not to be regarded as a bond, signed, sealed and delivered. It may contain and often does contain promises or proposals that are quite unworkable or impossible of attainment. Very few of the electorate read the manifesto in full. A goodly number only know of it from what they read in the newspapers or hear on television. Many know nothing whatever of what it contains. When they come to the polling booth, none of them vote for the manifesto. Certainly not for every promise or proposal in it. Some may be influenced by one proposal and others by another. Many are not influenced by it at all. They vote for a party and not for a manifesto. I have no doubt that in this case many ratepayers voted for the Labour Party even though, on this one item alone, it was against their interests and vice versa. It seems to me that no party can or should claim a mandate and commitment for any one item in a long manifesto. The appellant was the father of the deceased who got married with the respondent number 2. It appears that the appellant filed the appeal against an order of acquittal by taking aid of the proviso to Section 370 to read with Section 378 of the Code, claiming to be a victim. A question was raised as to whether the father of the deceased could be said to be a victim. The division bench held that in view of the amendment with effect from 31st December 2009, a limited right to the victim to file an appeal against the order of acquittal was of course given, but such right could not be conferred in case of an offence which was committed prior to the date of incorporation of the said proviso. In that context, the division bench held that right to appeal of the petitioner had accrued only after the decision in the sessions trial where the respondent numbers 2 and 3 were acquitted on 30/09/2010 and the petitioner was, thus, entitled to prefer an appeal. The division bench further held that the father of the deceased was also a victim within the meaning of Section 2 of the Code. We are in respectful agreement with the view taken by the division bench. With great respect, we are unable to follow the view taken by the full bench. Statement of Objects and Reasons of the Act states that the corporation will have special privileges in the matter of enforcement of its claims against borrowers. The full bench appears to have taken the view that the expression borrower is significant and limited to the industrial concern. With respect, we do not think that the expression used in the statement of objects and reasons should be viewed in such a strict light. We have no doubt that the expression borrower has been used compendiously to take in all persons who render themselves liable under the loan transaction. We are also unable to agree that the absence of specific provision in Section 32 to issue notice to a third party Surety is an indication of the legislative intention that such a surety cannot be proceeded against thereunder. The scheme of provisions of sections 29, 31 and 32 would clearly indicate that the remedy under section 32 is available against a third-party surety who has mortgaged his property also, and the Audi alteram rule could be read into section 32.